I am Lee Liberman-Otis. I am the Senior Vice President of the Federalist Society and the Director of our Faculty Division. And every year we hold a panel paper where young legal scholars present papers that are competitively selected, and they get comments from senior scholars, and then we have some questions. Usually we have done this in conjunction with the annual meeting of the Association of American Law Schools, but because that annual meeting this year was virtual, we decided to do it in conjunction with the Student Symposium, and we're delighted to see all of you here today. We're going to be doing this in groups of 2 papers and comments, and then Q&A from the audience, and then another 2 papers and comments, and then Q&A from the audience. We have both a live audience and a virtual audience, and we have both live and virtual commenters, so this is going to be a veritable hybrid feast. Without further ado, I would like to turn things over to Michael McConnell, who needs no introduction, and he is going to moderate our first session here.
Thanks, Lee. So I'm Michael McConnell. I was chosen to moderate because I used to be a young scholar, so it's totally appropriate. I'm just going to call on some folks and then help to moderate the questions afterwards. And beginning with, on my left, Josh Blackman.
Very good. All right. Thank you so much. It's a pleasure to see you all here in person. To those of you on Zoom land, hello, good to see you. We sit here with these masks or not, talking about the pandemic. But before there was a pandemic, there was a case called Jacobson versus Massachusetts from 1905, decided within a few months of Lochner versus New York. In 2019, Jacobson was an obscure precedent. But in 2020, Jacobson became a fountainhead for pandemic jurisprudence. Courts relied on Jacobson to resolve disputes about religious freedom, abortion, gun rights, voting rights, the right to travel, and many other contexts. And in 2021, governments began to impose vaccine mandates. Now I hope that the pandemic is, thank God, slowly ending, hopefully soon. Jacobson still retains a central place in our constitutional discourse. But what exactly did Jacobson say? Justice John Marshall Harlan's decision upheld the state's power to impose a nominal fine on a person who refused to be vaccinated. No more, no less. Yet judges now follow a variant of Jacobson that is far removed from the Lochner-era decision. And the Supreme Court is largely to blame for these departures from precedent. Over the course of a century, 4 prominent justices established what I call the irrepressible myth of Jacobson versus Massachusetts. I, of course, go up in the John Hart Ely article about the irrepressible myth of Erie. And in my view, this myth has 4 levels. The first level was layered in 1927 in a case that arose very close to us, Buck v. Bell. In this case, Justice Holmes upheld Virginia's eugenics law, which mandated involuntary sterilization for so-called imbeciles. And he used Jacobson as the leading authority. Or more precisely, Holmes recast Jacobson's limited holding. He wrote, quote, "The principle that sustains compulsory vaccination from Jacobson is broad enough to cover the cutting of fallopian tubes." My goodness, chilling every time I read it. In a single sentence, Holmes expanded the scope of Jacobson far beyond its narrow confines to support forcible intrusions onto bodily autonomy. Julie reminded me this morning that the Virginia colony for the epileptics and feeble-minded is about 30 miles from here in Stanton, Virginia, so we're very close to that case. The second level of this myth was layered in 1963. In Sherbert against Werner, Justice Brennan found that neutral laws that burden religion would be reviewed with something like strict scrutiny. But Brennan recognized that the court had upheld governmental regulations of certain overt acts prompted by religious beliefs or principles that invariably pose some substantial threat to public safety, peace, or order. Justice Brennan cited Jacobson as an example of this dynamic. Jacobson had nothing to do with religious beliefs, absolutely nothing. The case didn't even raise a free exercise clause claim. But with a single citation, Brennan transformed a substantive due process case into a free exercise clause case, even though Jacobson predated incorporation doctrine by decades. Hello, Elon, incorporation, right? And perhaps unwittingly, Brennan suggested that the usual free exercise clause jurisprudence would not apply during public health crises. The third level was layered in 1973, in a case you may have heard of, hopefully not long for the world, Roe v. Wade. Justice Blackman recognized a substantive due process right to terminate a pregnancy. But the court refused to recognize the unlimited right to, quote, do with one's body as one pleases. To support this limitation, Justice Blackman cited two cases. No relation, by the way. Justice Blackman cited two cases. He's M-U-N, I'm M-A-N. Okay. Blackman cited two cases, Jacobson and Buck v. Bell. With these citations, the court affirmed Holmes's misreading of Jacobson. And even worse, Blackman incorporated Jacobson into the court's modern substantive due process framework, even though Jacobson predated substantive due process by decades. Roe also extended Jacobson yet further. During a public health crisis, apparently, the state has extra powers to restrict abortions. Hello, Texas. The fourth layer of Jacobson's myth is of more recent vintage. In South Bay United Pentecostal Church versus Newsom, the Supreme Court refused to enjoin California's COVID restrictions on houses of worship. This shadow docket opinion lacked a majority opinion. But Chief Justice Roberts wrote an influential concurring opinion. He favorably cited Jacobson and wrote, quote, our Constitution principally entrusts the safety and the health of the people to the politically accountable officials of the state to guard and protect. In short order, this concurrence became a super precedent. In the span of 6 months, 140 cases cited it, and then more than 90 of which cited Jacobson as well. It isn't clear that the Chief Justice intended to adopt Jacobson's constitutional analysis as a general rule to review pandemic measures. Yet Roberts established a fourth layer of Jacobson's myth. Jacobson-level deference was warranted for all pandemic-related constitutional challenges. The lower courts followed the Chief's signal. This final layer of the myth, thankfully, was interred 6 months later in Roman Catholic Diocese of Brooklyn versus Cuomo after Justice Barrett joined the bench. The per curiam opinion followed traditional First Amendment doctrine and did not rely on Jacobson. But Jacobson stands ready to open an escape hatch from the Supreme Court's jurisprudence. I wrote this article in the middle of the pandemic and hopefully has some life beyond it. The article has 4 primary parts. First, I provide a history of common law during the Lochner era. Think back before incorporation. During that time, there were no tiers of scrutiny. The Supreme Court did not distinguish between fundamental rights and non-fundamental rights. The Bill of Rights had not been incorporated. What we now call rational basis review was actually somewhat rigorous. Moreover, the court treated economic property rights in the same fashion as it treated personal liberty. You cannot separate Lochner and Jacobson. They're decided in the same mode of thinking. So when we review decisions from this period, we have to place them in the right time frame. The second part of my article recounts the history of Jacobson. In 1902, Massachusetts and Cambridge law provided that unvaccinated people would be subject to a $5 fine, about $130 in present-day value. Henning Jacobson was a Lutheran minister. He refused to be vaccinated. In his youth, he had taken a smallpox vaccine, had a very bad adverse reaction to it. The city charged him with violating the law. He raised defenses under the state and federal constitution, but not based on religion, nor could he. The First Amendment was not incorporated. He was convicted by a jury trial in order to pay a $5 fine. On appeal, the Supreme Court affirmed his conviction. One fun fact, while Jacobson was sort of on bond, the city of Boston sent him to the delegation to the World's Fair, unvaccinated, to represent the city. So this wasn't a very important issue to them, right? He was in high society at all times. So like today, it's a lot of virtue signaling, I suppose. Part 3 of my article talks about this first layer. in Buck v. Bell. Then we talk to Sherbert versus Verner, and then we go to Roe versus Wade, and then South Bay Pentecostal Church. Now, where do we stand today? Jacobson was pruned, but not overruled. This precedent still stands, waiting for some future crisis of unknown duration. I had hoped the Supreme Court would clarify what the scope of Jacobson was, but instead they sort of reflexively followed it. And then later, Chief Justice Roberts said, "Oh, no, not me, that's not what I intended." He sort of ran away from it. But I hope sincerely that when we have the next public health crises, that courts actually read Jacobson, understand what it says, and realize that there's no escape from the normal rules of constitutional law, even during a pandemic, which lasted 2 years apparently. Thank you all. Thank you to Michael for hosting us and to Julia for giving some comments.
Thank you. So thank you, Josh. As you know, I think this is a very important project, and I commend you for laying out with such insight and nuance and comprehensiveness what I think of as the afterlife of Jacobson v. Massachusetts. I'm confident this paper will have a long afterlife and will not be forgotten as soon as the acute phase of COVID-19 fades from our memory. So since I only have a short time to comment, I will limit myself to two topics, both of which are things that are important to this paper and also important to other work of yours, and which I think you are certainly not done with. The first has to do with precedent, in particular Supreme Court precedent, and the second concerns the police powers of state governments. So first, precedent. When I read a lot of Supreme Court precedents, I think of an old joke about someone who goes to a museum where there is a portrait of George Washington and asks the guide, "Hey, is that what George Washington really looked like?" And the guide responds, "That's what he looks like now." And this is just true of a lot of Supreme Court precedents, that you see them cited for all kinds of stuff, and then you go and read them, and you think, wait a minute. This isn't about the power to actually jab someone, right, to catch and jab. This is about paying a fine, and how can this be? So, thus, the Penn Central multi-factor test for when a government regulation goes too far and amounts to a taking is not actually laid out in Penn Central. It's more a creature of Kaiser Aetna, a case decided the following year when the Supreme Court recasts Penn Central or clarify, if you want to be a little bit gentler. And but all that said, I think Jacobson is an especially egregious example. It was cited early on, or within 20 or so years, as Josh points out, by Oliver Wendell Holmes. Whether Holmes ever actually read Jacobson or not, I cannot say. It is very disappointing that he is willing to so mischaracterize it. And that's not the end of it, of course. So I have two questions for Josh about precedent. And they are broader questions, I think, than you can possibly answer in this paper, but I hope you will take them to heart. First question is there such a thing as a super precedent? And if so, how do we define super precedent? We hear that word a lot, probably most famously with respect to Casey, sometimes with respect to Roe. You use the word super precedent in a different way in this paper, and it interested me a great deal that you called South Bay Pentecostal Church v. Newsom a super precedent, but it also puzzled me because they didn't last all that long. The shelf life of the case was not, as you point out, it faded pretty quickly. I would think a super precedent would have more staying power. I mean, it got cited a lot, but it's not clear that it made much of a difference. I think this is an area that is worth exploring, particularly as we all await Dobbs, which didn't come down this morning.
No, it did not.
It did not come down. But we are still waiting, and we will have, and that I think will add some more very interesting insights into this phenomenon, which may actually be the null set of super precedents. Second big question I have for you concerning precedent is, I would like to know more about your theory of how courts should apply old precedents, especially ones like Jacobson, which, as you say many times throughout this paper, was decided against a very different backdrop, a very different doctrinal backdrop. Are such cases just not able to be applied, such that, as you say at the very end of the paper, the court should limit Jacobson to its facts? And yet, at other points of the paper, you seem to be suggesting that Jacobson might be very useful to courts and mean a lot more. In particular, the Second Circuit case that I think you discuss on page 37 you suggest, I think, that there might be a lot more life in Jacobson than simply limiting itself to the facts. But thinking more broadly about precedent, do you agree with my colleague Fred Schauer, who has argued that for the Supreme Court of the United States, with its, quote, small and self-selected docket, heavily populated by issues of high moral and political valence, there does not appear to be in place a stare decisis norm, that is, a norm pursuant to which most of the justices, most of the time, would feel compelled by internal belief or external pressure to do what they don't feel like doing. Is this true? If so, then maybe Jacobson it doesn't matter that the justices, at least a good bit of the time, are not reading their precedents all that carefully. It pains me to admit that, I have to say, because I really, really, as you can tell, don't like what Oliver Wendell Holmes did in Buck v. Bell with respect to mischaracterizing the court's work. It's sloppy, it's a bad example for students. It's not how I think the law should function, but we have to be realistic. And if my colleague Fred Schauer is correct, then, well, at that point, maybe we should just shrug a bit more than you do in this paper. Another colleague of mine, Richard Ray, has suggested that we think of precedent as more of a permission, more of a kind of, it gives guidance, that we should give up on the idea that Supreme Court precedent is, or might even become, a strong constraint, but what does give a certain amount of limited discretion and so forth in crafting these ideas. Richard Ray is obviously in a substantial part inspired by some of the work that Justice Thomas has done in recent years, which I think has applications for your work too. All right, second big topic is that of police powers. You and I have talked quite a bit about police power over the years. Jacobson, the statute, vaccination mandate at issue in Jacobson obviously is enacted pursuant to a state's police power. And as we have discussed over the years, the police powers of states in the United States system have always been reasonably strong. They've certainly extended to imminent things that are actual nuisances or imminent nuisances that could cause real harm to identifiable individuals. That said, there have certainly been changes in terms of the scope of the police power. Jacobson has decided in the early 20th century, after a time of expansion of the police power, as a lot of recent work, including Herbert Hovenkamp and John Compton, have pointed out, where morals regulation, which there have been a lot of disputes about the constitutionality of, morals regulation became more common. And in terms of thinking of the scope of police powers in epidemics, we have certainly not seen our last pandemic. There are, I think, profound political economy questions that have not as yet received the attention that they deserve. As John Witt notes in his recent book, American Contagions, Epidemics and the Law, From Smallpox to COVID-19, in times of crisis, times of disease crisis, the law has tended to protect property rights for the wealthy and attend to the civil liberties of the powerful. But the less wealthy and less powerful have often seen economic pain and even economic devastation and restrictions, sometimes very serious restrictions, on their personal liberties. Right now in US law, it's very difficult, United States constitutional law, it's very difficult to challenge these exercises of the police powers unless one has some kind of fundamental rights hook of some sort. That's one reason, of course, that the First Amendment has become such a powerful engine, often the only engine, but it leads to a lot of what is described as First Amendment Lochnerism and so on and so forth. And so I am very curious to know what you think the limits of the police power are, full stop, both in epidemics and not. So I'll stop there.
Would you
Want me
like just to take
are we
a
responding
minute?
now or are we doing the second paper?
I think, well, maybe next paper and then responses.
Okay.
But I got my notes, so I think we'll do this.
In that case, we turn to Michael Morley from Florida State.
Thank you very much, and I'd like to echo Josh in thanking all of you for coming, as well as our commentators for your time. So my paper looks at voting during pandemics. It's part of a series of articles that I've written looking at various types of election emergencies. And it begins by offering some historical perspective, comparing the elections conducted in the midst of COVID-19 to elections conducted back in 1918 in the midst of the Spanish flu pandemic. Perhaps one of the most remarkable observations is that because the Supreme Court greatly expanded the scope of the constitutional right to vote over the course of the 20th century, back when disputes arose concerning voting during the Spanish flu, there weren't substantial constitutional protections. And so there were cases where election officials would make adjustments to the rules governing the electoral process, which is a somewhat euphemistic way of saying they would simply ignore the restrictions of election law in order to provide additional protections and allow people to vote under safer circumstances. So, for example, in one state, there was a residential school, and the people living at that school were entitled to vote. And so, because a quarantine had been imposed, at the last minute, election officials decided just to declare that school would be a polling place, even though the deadline for identifying polling places had passed. They didn't go through the public notice provisions for recognizing new polling places. Everyone living at the school cast their vote, treating it as a polling place. Of course, the election winds up coming down to those votes, and ultimately the votes are deemed illegal and thrown out, even though, of course, we were in the middle of a pandemic. This was a prudent public safety measure. The fact that there was no statutory authorization for election officials to allow them to treat the school as a polling place was deemed not only sufficient in itself, but an important restriction to enforce in deeming those votes invalid. There was no consideration whatsoever of constitutional concerns. In an eerily prescient parallel, in another state, election officials, because people had been quarantined at home with Spanish flu, election officials took it upon themselves to go to their houses to bring them ballots so that they could fill out the ballots and have them returned to the polling places, basically creating their own form of absentee voting on the fly with no statutory authorization. And again, those unfortunately dispositive ballots wound up being rejected because the courts found that enforcing the rules of the election was more important than creating new opportunities to vote. But again, this is in an era before the Anderson-Burdick test, which is the standard that courts currently apply in determining the permissibility of restrictions on the right to vote. And the courts simply aren't looking at this from a constitutional perspective. Fast forward to the COVID-19 pandemic, in contrast, and virtually all of the litigation that arises concerning the enforcement of election-related constraints deals with various constitutional protections, such as equal protection considerations, Anderson-Burdick considerations. And courts struggled in many cases with trying to figure out the correct approach to apply. And in fact, this leads into the second part of my paper. In seeing how our election system as a whole adjusted to the threat of COVID-19, and I want to take this opportunity to reiterate and underscore that the 2020 election was a shocking success, given the huge, I would say unparalleled, except obviously we just got to talk about the Spanish flu, but a worldwide pandemic. Election officials engaged in Herculean efforts to make the necessary adjustments to safeguard the right to vote and to ensure a safe, fair, and accurate process. And so the second part of my paper looks at how exactly that happened. What were the legal mechanisms through which that happened? In some jurisdictions, there were simply general state of emergency laws that allowed the governor to simply suspend any state statutes or any state deadlines, including provisions of the election code, if enforcing them would interfere with efforts to preserve public health, safety, or welfare. In other jurisdictions, the Secretary of State or the Chief Election Officer enacted emergency regulations or used emergency guidance, emergency interpretations of statutes. So one of the most common examples of this that we saw, for example, is in states that had for-cause absentee voting, where not everybody could vote absentee. You had to fit into certain special categories. For states where disability was a category, several secretaries of state said the risk of COVID-19 qualifies as a disability that would allow everyone to take advantage of the opportunity to vote absentee. Perhaps the most successful approach is embodied in what I refer to as election emergency laws, which are statutes specifically tailored to dealing with emergencies. They identify the particular officials who were allowed to make departures from the rules governing the process. They specify the types of departures that may be taken from the process. And one of the main suggestions of this paper is such election emergency laws can even go further by setting forth what I refer to as election emergency red lines. The legislature, in advance of the crisis, can determine not just here are certain steps that we want to authorize, here are certain measures that we want to allow to be taken, or certain fallback provisions we want to allow to be implemented, but there are certain types of measures, for instance, allowing internet-based voting, that even in the midst of an emergency, we want to put off limits because of concerns regarding other aspects of the process. And for jurisdictions that did not use any of those other methods, that did not adequately address their election emergency using the governor's suspension power, emergency regulations, or election emergency laws, they, of course, were relegated to ad hoc litigation, in which very complicated issues, very difficult issues, were being litigated on an expedited basis, sometimes on an ex parte basis, before generalist judges who were then in the position of trying to figure out which sorts of measures to suspend, which sorts of modifications to make to the rules governing the election process. The final part of my paper shifts to an analysis of the election litigation that we saw with regard to COVID-19. In the months leading up to the election, we hit a high point of over 400 cases, state and federal, dealing with challenges to various aspects of the electoral process in state and federal courts across the country. And my paper gets into a lot of the details of these cases. Given the time here, I want to just briefly touch on 3 main points. The first is the Supreme Court in many of these cases applied what was referred to as the Purcell principle, which is a notion that traces back to a precedent, perhaps quickly becoming a super precedent, I don't know, that specifies that a federal court can't change the rules of an election shortly before an election is to occur. And of course, one of the big questions is, what does shortly mean? As we just saw a few days ago in the Alabama case, or apparently 84 days before a primary is shortly. The Purcell principle can't apply in the context of an election emergency. The whole point of an election emergency is that implementing the rules of the process as you ordinarily would is going to create unexpected risks, unexpected problems, unexpected burdens. And so by their very nature, the rules have to be changed. Outside circumstances have already changed the situation. And so I would suggest the Purcell principle, whatever its problems elsewhere, the Purcell principle cannot be applied in the context of election emergency litigation. Secondly, the U.S. Supreme Court in Democratic National Committee versus Republican National Committee set forth a remedial hierarchy for election emergency cases, specifying that whenever possible, you should alleviate constitutional burdens by changing the rules governing the election, suspending certain requirements or modifying certain requirements, and leave a postponement or an extension of the election, a change in the deadline for voting, as the extraordinary remedy, that's the fallback only if lesser modifications fail. And finally, perhaps one of the biggest takeaways from election emergency litigation is the importance of the laches doctrine, that once courts have issued orders that allow voting to occur through certain methods, once voters have relied on court orders and have relied on apparently legal methods of voting, coming back after the fact and then attempting to challenge the legality of votes that at the time they were cast were by all appearances legal and consistent with court order is disastrous for an electoral system, as we've seen. So I guess there's certainly more in the paper, but I will stop there.
And now it's my pleasure to welcome not my colleague Bernie Mylar from Stanford, but instead our colleague here at University of Virginia, Bertrall Ross. So welcome, Professor Ross.
Thank you, and thank you to the organizers of the symposium for inviting me to be a commentator on Professor Morley's article. It is always a pleasure to engage Professor Morley's work. So the article on election emergencies has a timeless quality to it. It is the first comprehensive scholarly examination of elections during pandemics, and it is long overdue. I hope that even as this pandemic subsides and hopefully continues to do so, courts and policymakers will use Michael's work as a foundation to prepare an election plan for the next inevitable emergency.
Now, what I appreciate the most about Michael's article is its meticulous, detailed, and novel account of elections during the two most devastating pandemics in this country's history, the 1918 Spanish flu and the
Oh, here, echo. Can we kill these mics maybe while he's speaking? Thank you.
All right, is everything to continue?
Josh, one more push.
It won't,
Okay.
I'm not gonna hold it down. Go ahead.
Okay, I'll continue on. And so what I appreciate the most about Michael's article is this detailed account of elections during the two most devastating pandemics in the country's history, the 1918 Spanish flu and the COVID-19 pandemic. What that examination taught me was that election administration challenges that we faced during the COVID-19 pandemic were not entirely new, but that unfortunately we had not adequately learned the lessons from the past. Now, as is all too familiar when emergencies fade, attention tends to wane, leaving us in the same precarious position when the next emergency arises. Beyond the important accounts of elections during pandemics, Michael advances what I agree should be considered the three fundamental principles of sound election systems. First, all eligible voters must have reasonable opportunity to cast their ballot safely and have them counted. Second, the system must minimize the possibility of mistake, irregularity, illegality, accident, or fraud. And third, the system must be designed in a way that bolsters public confidence in the accuracy and integrity of the election results. To implement these principles, Michael argues that an election system must be robust enough to withstand a wide range of possible emergencies. For it to be robust enough, election systems must permit a wide range of different methods of voting when emergencies arise. Election emergency statutes must also ensure that the appropriate election officials are empowered to adopt the necessary adjustments to the electoral process during emergencies. And finally, election emergency statutes must impose what Michael labels election emergency red lines, which are changes to the electoral process that election officials are prohibited from adopting, even in cases of emergency. Michael also includes proposals for courts when adjudicating litigation arising from election emergencies. Now, due to the limits of time I have with you, I'm going to put aside his proposals for courts. But I will say that I concur with much of what he has proposed, but I do worry about threats to judicial legitimacy that might arise from their more active intervention into election emergency disputes. Election adjudication always poses the risk of politicizing the court in ways that can hamper its capacity to present itself as an impartial adjudicator in future disputes that are both election and non-election related. This, of course, is not a reason to excise courts from these disputes because they might be the only institution positioned to resolve such disputes, but it's a reason for the courts to proceed with caution. Here I want to focus on Michael's three fundamental principles for sound election systems that he proposes that lawmakers do in the context of emergency. Now again, I agree with Michael's account of the three fundamental principles of sound election systems. Let me start by saying that I think his proposed response to emergencies, which include expanding early voting and no absentee balloting, moving, increasing, or consolidating polling places, authorizing election officials to travel to hospitals or assisted living facilities where voters may be confined, and or conducting curbside and drive-through voting for medically vulnerable voters could be designed to implement the first two principles of the sound election system. The first being that all eligible voters have a reasonable opportunity to cast their ballot safely and have them counted. And the second being that the system minimizes the possibility of mistake, irregularity, illegality, accident, or fraud. I would even go so far as to argue that they not only could be designed to implement the first two principles of the sound election system, but that in the 2020 election, they were designed towards implementing these principles. Despite the pandemic emergency, we had record level turnout in the 2020 presidential elections, and that was due in part to the availability of alternative methods of voting that Michael describes in this article. And furthermore, the evidence of mistake, irregularity, illegality, accident, or fraud was minimal, with nothing to suggest that the state responses to the election emergency introduced more mistakes, irregularity, illegality, accident, or fraud than prior presidential elections. And yet, because of the propagation of the big lie, the election failed to satisfy the third principle of sound election systems, which is that they be designed in a way that bolsters public confidence in the accuracy and integrity of the election results. I would argue that it wasn't a matter of design. Even if Michael and others might point to design flaws regarding implementation of alternative voting methods and counting methods during this past presidential election, I doubt that a flawless implementation of such methods would have had much of an effect on public confidence in the accuracy and integrity of the election results. The reason being that due to the information silos in which Americans exist, that leave them vulnerable to misinformation and disinformation campaigns, public confidence in the accuracy and integrity of the election results during an emergency will depend in part on the willingness of candidates on both sides to accept the election results. But I do think that public confidence in the accuracy and integrity of election results will depend only in part on candidate behavior, which means that there is room for some optimism and opportunity. A precondition for bolstering confidence in elections is that the public have confidence in elections in the first place. Thus, to bolster confidence in possible responses to election emergencies, we need to create public confidence in the alternative voting methods that might be used in emergencies. The best way to create confidence in such alternative voting methods is to employ them during non-emergency periods, something that Professor Morley does not propose. In other words, states that haven't already done so should implement additional methods of voting like no-excuse absentee voting, expanded early voting, and curbside voting now. States that haven't already done should address mistakes, irregularity, or fraud concerns associated with mailing everyone a mail-in ballot now. States should develop rules for third-party ballot collecting that will expand access to the polls while addressing concerns about mistake, irregularity, illegality, accident, or fraud now. By implementing alternative voting methods responsive to emergencies during non-emergencies, you can create confidence in such methods. When implemented for a period of time, people become acclimated to the alternative methods of voting. And furthermore, election lawmakers and administrators have the opportunity in each election to make the necessary adjustments and modifications to both enhance access and reduce the risk of mistake, irregularity, or fraud. The result being that when an emergency arises again, there will probably be less need to make major changes to election methods, as the availability of multiple alternative avenues of voting will give states the flexibility to respond to a variety of emergencies. Now, I'm not so saying what to think that the proposal for developing alternative voting methods responsive to emergencies during periods of non-emergency will bolster all Americans' confidence in the accuracy and integrity of election results. The information silos and sort losers will continue to be a problem in the future based on the precedent set in the 2020 election. But I do think we will be better positioned to bolster public confidence in the accuracy and integrity of election results than if we waited for an emergency to implement such alternative voting methods. So let me conclude there, and thank you again to the organizers of this symposium for inviting me, and to my Professor Morley for sharing his work.
So now we have an opportunity to take questions both from the folks here in the room, and also some may be coming in from the wider Zoomosphere. So here, let's see, did the microphone disappear? Okay, Nick, so Nick, will you just bring it around? And so raise your hands and Nick will bring you the microphone. Please speak distinctly into it so that those who are listening from afar will be able to catch the question.
Hello, hi. So we talked in the beginning about the standards of review as they apply to the pandemic cases and the super precedents, Roe v. Wade, things like that has to do with people's bodies. And then the police power, which is obviously implied, it's not mentioned in the text. Are you concerned that regardless of what standard of review you use, it always ends up being some kind of a balancing test between the government wants to do this, you don't want to do that, you try and ground it to get in a higher basis of review based on, if it's First Amendment, you seem to get the most, it's its own kind of ticket. If it's explicitly in the Constitution, you get more. What do you think of a kind of a private property approach to drawing clear boundary lines for appropriate government action, inappropriate government action, to avoid kind of the sliding scale effect when there's in emergency situations?
Sure. And I apologize for this dreadful echo. Oh boy. I feel like I'm the great, wonderful Oz. Right. Yeah, maybe if, Bertrall, if you're on Zoom, to mute. So I think I heard about maybe 20% of the question. Private property during a pandemic seems to sort of fade, and maybe I can hit one of Julia's questions as well. Businesses were shut down completely indiscriminately, right? I'll give you an example. In Pennsylvania, the government decided that certain businesses were essential and they could stay open, and other businesses were not essential, they could not stay open. So one essential business was the Peeps factory in Bethlehem, Pennsylvania. They make the little marshmallow candies for Easter, and my goodness, we needed candy Easter marshmallows for Easter, right? But gun stores which sold a constitutionally protected item, were not essential. There was substantial litigation by businesses trying to seek effectively a taking, right, just compensation for businesses being closed. And with the exception of one federal court in Western PA, all those cases were unsuccessful. Courts more or less said, during a pandemic, we're exercising the police power, we're not engaging in the taking of private property. I think legislatures should go proactive. This is kind of the, following up on Bertrall's point, enact statutes saying if we shut down your business during a pandemic, we'll provide you compensation in advance, right? If we really need to say we're putting you out of business, let the government pay for it. And we can do that now. It's not just expanding voting rights, it's expanding property rights. Sorry, Bertrall.
Did I see a hand over here? Oh, no, apparently not. Yes, here we go.
Yeah, thanks to everybody for doing this. Professor Morley, so I've got a question. Professor Ross mentioned the third thing that matters in elections here is public confidence. Do you worry that kind of taking the Purcell principle away from emergency situations might lower public confidence with the increase of unelected judges kind of butting into the election process?
So if states are adequately prepared with election emergency statutes that give election officials authority to suspend or modify certain requirements and lay out in advance the authorities necessary to deal with these crises, then, assuming the courts agree, the issue, of course, doesn't even arise. So if you're talking about courts already, you're in a second best situation. And then in choosing between what the outcome of the second best situation is, you're choosing between an emergency has made voting substantially more burdensome, substantially more risky, substantially more life-threatening, and we're not going to do anything about it because the emergency arose at the last minute, which is kind of the definition of an emergency, or the court will impose an order that modifies the rules of the process, suspends certain rules in order to address that last-minute emergency. And so to the extent that failure to adequately modify the rules of an election process in the face of an emergency burdens constitutional rights, the Purcell principle is categorically shackling courts from ever being able to provide a remedy. And so I just think the circumstances in which the principle first arose were just so fundamentally different from an emergency context that carrying it over to an election emergency scenario is just inappropriate.
So can I follow up on that and just ask, let me follow up on that and just ask, is the public perception that the election is being properly conducted, does that ever lead to a different result than just properly conducting the election?
Absolutely. And I would look at bigger picture issues for this. So for example, transparency type measures, the extent to which poll watchers, for example, are able, do they have to sit far away? Can they sit closely enough where they're able to actually see what's going on? Something like that has nothing to do with are people able to vote. It has something. It has something of a connection to trying to minimize the risk of irregularity. However, one of the biggest advantages to ensuring that poll watchers are able to have access to all key parts of the process is as a way, both on the one hand, of bolstering public confidence in the outcome of the election, and also helping to dispel at least perhaps some of the crazy conspiracy theories and aspects of, foundations of the big lie, that if people either were in the room or at least had the opportunity to be in the room and can show that no, there weren't, briefcases of ballots from Russia being counted, then hopefully, again, you're not gonna squash all the conspiracies, but at least you can chip away at it. You can start to minimize it.
Lee.
So one thing I've puzzled about is the problem of that there's actually a lot of virtue for public confidence purposes, and I think potentially for averting irregularity, to a decentralized system where results are coming in simultaneously and people don't know what the vote difference is. for purposes of how many votes do we need. For example, President Trump doesn't know that he needs to find 11,000 votes or whatever that was. And the expanded measures do seem, to me at least, potentially to complicate that. And I don't know if anyone has come up with a good solution to that problem.
So that's an excellent point, and I think that underscores, number one, why election emergency legislation is far preferable to just ad hoc litigation. When a court is facing an issue, its only options are, or at least the way the courts have approached it in the context of the 2020 election, its only options were suspend the requirement or not, issue an injunction or not. So with absentee ballots, for example, either suspend the signature match requirement or don't. If legislators are crafting election emergency statutes, they can provide fallback requirements. They can provide alternatives. It doesn't become this binary either or, where, number one, the remedial options become just a light switch, either keep the law in place or suspend it. And you'll see plenty of courts saying, counsel, I don't have the authority to rewrite the law. I don't have the authority to put in an alternate, less burdensome security requirement to try to maintain public confidence. So I think you're right. Legislatures have much more flexibility in crafting election emergency laws with fallback alternatives, whether it's alternate ways of identifying yourself, alternate ways of confirming that the ballot is valid, whereas a court isn't going to do that. The other important point that I think your comment raises is, at the end of the day, you could have the most perfectly conducted election there is, and if the public isn't willing to accept the results, then you have unnecessary instability. You are undermining confidence in the process. And so that's why I think having all three of those principles, right, ensuring access, ensuring your accurate results, and then ensuring the appearance of legitimacy, right? I'm reminded of Buckley v. Vallejo, right? It's not just corruption, but the appearance of corruption we want to fight. Here, it's not just accurate election, but the appearance of the accurate election that the government has an important interest in safeguarding.
Let's now proceed to the next set of papers, and let me invite Jonathan and Ilan and Akil to come down.
I need my computer. I'll hand it to you. I'll sit right over here. Are we done on Zoom as well?
And is Bernie Mylar with us over Zoom?
Nice to see you again. Yeah, exactly. Hi, Professor McConnell. How are you?
I'm good.
Thanks for doing this. Josh, do you want your... Oh, yeah. Here, you want me? Yeah.
Now, how Jonathan has managed to produce such an impressively researched paper while living the busy life of a law clerk, I have no idea, but here he is.
The secret was doing it before I started clerking. Well, thanks, Professor McConnell, and it's a pleasure to be here with all of you and to be speaking alongside scholars whose work I so deeply respect and admire. And special thanks as well to Professor Mylar for agreeing to comment on my paper. My subject, to begin, let me just say a few words about how I came to this project and give a brief sketch of my argument. My academic background is in the history of political and legal thought, and this paper is very much in that vein. My subject is the theory and practice of statutory interpretation on the English courts. There's been a good deal written about how English and colonial judges interpreted statutes at the time of the founding. And those studies have centered on the question of what method or methods of interpretation were implied by the grant of judicial power in Article 3. But no historian has finished the story connecting those 18th century debates to the theory and practice of interpretation in England in the centuries after the American founding. And so that's what I try to do in the paper, essentially. Now, the obvious question to ask about such a project is who cares? What relevance could English debates about interpretation in the 19th, 20th, and 21st centuries have in the United States today? In the paper, I try to show that the English history is relevant for two reasons. One is historical and the other is normative. So let me set out the historical argument first and then move to my normative claim. Most of us are familiar, I think, with the kind of standard reasons that textualists and proposivists give for their respective approaches to interpretation. Those reasons sound in the rule of law, the separation of powers, and appeals to democratic legitimacy. But textualists and proposivists sometimes make a different kind of argument, namely an appeal to the authority of the English tradition, claiming that their preferred method of interpretation is deeply rooted in the common law and still practiced in the English courts today. Hart and Sachs had a version of this argument in the 1950s. Scalia made this argument later in the 1980s. And what's curious about these appeals to the English tradition, and what initially prompted me to look into this history, is that both textualists and proposivists rely on the same basic story about the history of English judging. They simply draw the opposite conclusions from it. So to grossly oversimplify for purposes of time, the standard cribbed story goes something like this. In the beginning, early modern English judges just assumed that a statute's meaning was identical to the meaning that its authors intended. And that's why in the 16th century, Lord Coke instructed judges to read statutes in light of their mischief, the problem that they were trying to solve. The judge needs to know the problem that prompted the legislature to act in order to ascertain the legislature's purpose. That approach persisted for some 3 centuries, so the story goes. But by the time of the American Revolution, the English courts abandoned it for a kind of proto-textualism. The key case there is a case called Miller v. Taylor from 1769. And that case supposedly announced a new rule. Whatever the legislature thought it was doing was simply not relevant. It was the objective meaning of the statute's text that mattered. According to the standard story, that textualist approach persisted, basically unchanged, across the 19th and 20th centuries. England was a textualist idol. Then, inexplicably, in the 1990s, the courts again reversed course. In a case called Pepper v. Hart from 1992, the English High Court made clear that statutes needed to be interpreted in light of their author's purpose, reinstating the early modern status quo ante. So that's basically the narrative, the standard story. Scalia used it to argue that the English became textualists in the 18th century because that's the era in which the constitutional distinction between the legislative and judicial power came into focus. In his telling, the American court's turn to proposivism in the 20th century represented a rupture in a long-running Anglo-American tradition, a reversion to a retrograde medieval approach to statutes. Proposivists, by contrast, have argued that textualism was the interloper, and that proposivism has a much deeper pedigree, stretching all the way back to the Elizabethan era, and that since the 1990s, it's again become dominant on the English courts. So what I try to show in the paper is that both of these arguments are unpersuasive because they're predicated on mistaken historical premises. To explain why, let me just briefly sketch the main claims of my paper. The first is that debates about legislative interpretation made no sense before the 19th century. Before that time, English judges simply had no access to evidence of legislative purpose, no records of debates in Parliament, no committee reports, no official statements of government policy. It's true that judges often tried to read statutes in light of the mischief that gave rise to them. But as Sam Bray has shown in a recent article, it's a category error to confuse a statute's mischief, the problem in the world to which it was responsive, with the statute's purpose, the prospective state of affairs that its authors hoped to bring about. In other words, one can read a statute in its historical context without falling back onto its author's subjective purposes. And that's, in fact, what the early modern English courts did. Second, I try to show that once judges did begin to wrestle with the question of legislative intent, and this is approximately in the early Victorian period, they were deeply divided on the question. The relation between statutory meaning and authorial intent was contentious for most of the 19th century. It wasn't until the end of that century that the House of Lords, which was in effect the Supreme Court of England, settled the debate in favor of a kind of proto-textualism. That moment came 130 years after Miller v. Taylor, a case that had no discernible influence on Victorian interpretation. What that means is that English textualism is an early 20th century phenomenon, not an 18th century one, as both Scalia and Hart and Sachs claimed. Moreover, once the English courts did embark on that textualist project, it didn't go so well. The Victorian proponents of formalism had promised that it would discipline statutory interpretation, removing the contingencies of judicial personality and partisan politics from the interpretive process, turning statutory construction from an art into a science. But over the course of the 20th century, enterprising judges found ways to maneuver around the strict rules that the House of Lords had set out. And that, in turn, led to intensifying criticism of textualism, as judges and scholars argued for a new approach to statutes, one that took into account not merely the statute's words, but the purposes they were meant to further. And that leads to my final point. When the English courts eventually relented and abandoned a strict kind of textualism, the sort of purposivism that emerged, and the purposivism that's still dominant in England today, was fundamentally distinct from the kind of purposivism that Hart and Sachs advocated. For essentially separation of powers reasons, the English courts have continued to insist that Parliament's subjective purpose, what past legislatures hoped their statutes would accomplish, is categorically irrelevant in nearly all cases. To index the meaning of a statute to its author's intentions would be to unconstitutionally intrude on the power of the judiciary to interpret and apply the law. Instead, the English courts seek out the statute's objective purpose. That is to say, the purpose that a hypothetical, reasonable legislature would have possessed, given the words of the statute and the context in which they were enacted. And for that reason, evidence of what the law's authors intended, what we call legislative history in American debates, is inadmissible in most English cases as a matter of judicial principle. So those are the paper's basic historical claims, and the normative lessons that I try to draw from the history flow directly from them. For textualists, I think the English story neatly illustrates the limits of formal approaches to interpretation. It shows that any interpretive method, no matter how systematic, will ultimately be unable in practice to discipline and depoliticize statutory interpretation entirely. For purposivists, meanwhile, the history I recount shows that it's possible to do purposivism without legislative history. A statute's purpose, in other words, is not necessarily identical to the historical purpose of its authors. And if that's right, then American purposivists need to provide a more robust account of why exactly we should rely on legislative history to resolve ambiguities in the text, rather than relying on the kind of objective purpose that the English courts center today. So hopefully that's enough to kickstart our discussion. I'll leave it there and turn the floor over to Professor Myler, and look forward to your questions.
For inviting me to comment on this paper. I have to apologize because the audio went out for the first few minutes of Jonathan's remarks, and so I don't have the benefit of those until he got to the summary of the paper. I just want to begin by saying that I just found this paper to be a shockingly gripping read about statutory interpretation, and now I'm not seeing the room, so I think maybe I should pause my remarks until I can see everyone again.
We're hearing you, Bernie.
Okay, sorry, I wasn't sure whether I was on screen or not. Great, so I found this to be an incredibly gripping read where it was kind of a page turner about statutory interpretation, and also just a really compelling and fascinating account of the history of statutory interpretation in a way that I found, quite accurate to the earlier history as well as the later developments. And I just wanted to point out three particular things that I especially liked about the paper. First of all, I think that it has a valuable and heretofore underemphasized revelation about the sort of role of different and evolving technologies on the ability of people to use different forms of legislative history or to think about legislative intent in different ways. So in particular, it reveals, the sort of history of not writing down legislative deliberations, and then when that changed and when Hansard became popular, and how that may have influenced and affected the developments in how British courts thought about legislative intent. Secondly, it also, I think, did a really useful job of separating out different meanings of intent and different understandings, and also highlighting the earlier equitable understandings of a purpose of a statute as opposed to later understandings of a kind of empirical version of intent. And then third, I think it also illuminated in a really interesting set of ways the differences in the debates about statutory interpretation and the nature of statutory interpretation between England and America, and how those differences could inform contemporary approaches to statutory interpretation in the American context as well. So I have 4 questions that I think I would like to elaborate on a bit in the time that remains to me that maybe would bolster the paper even further. And they're of varying natures, going from perhaps the more specific to the more general. So the first one actually is pretty specific and has to do with the role of Lord Mansfield in the 18th century. So Mansfield was one of the judges in Miller v. Taylor, which Jonathan gives some important consideration to in terms of changing how the British courts think about statutory interpretation. And as we know from the colonial American history and context, a lot of the members of the founding generation were really skeptical of Mansfield. So I'm curious about that, how we think about that skepticism about Mansfield in relation to these developments and the centrality of Mansfield potentially to changes in understandings of legislative history. And additionally, Mansfield, I believe, was the first of the judges to really empirically refer to his deliberations as a member of parliament in interpreting a statute. So how does that role, that joint role as both a legislator and a judge, then affect how we might think about Mansfield's role in transforming interpretation within the English context? So that's the first question about kind of the role of Mansfield and how we should think about that. There's another question that sort of lurks behind the paper that I would love to hear you develop either in this context or in another one. And that's the question of the respective legitimacy of these various modes of interpretation of statutory interpretation. And so on page 37 of the paper, you refer to the idea that, or in a judicial decision, that decisions of the highest authority show that the interpretation of an act of parliament must be collected from the words that the sovereign has made into law and nowhere else. So that seems to kind of refer to a theory of authority as, the law authorized by the sovereign. And then elsewhere, you also kind of talk about the sort of democratic basis of different modes of interpretation. On page 43, the idea that legal certainty demands that the rules by which the citizen is to be bound should be ascertainable by him. So where does democratic legitimacy or a lack thereof fit into these different modes of interpretation, and how should we think about them in relation to those various modes that you identify? Then third, I think another background question in the paper is how much of this applies not only to statutory interpretation, but to constitutional interpretation, and how should we contemplate that application? You have a very tantalizing footnote on page 3 saying that one might think that these approaches are appropriate depending on the statute's substantive content, that equitable interpretation is most fitting in the constitutional context, that objective meaning should control the interpretation of tax statutes and so forth, or depending on whether the statute regulates primary conduct. So I'm curious about what your answer would be about how much of this should in fact apply to constitutional interpretation as opposed to simply within the confines of statutory interpretation. And then the final set of questions is about developing the American implications. I think the paper is a wonderful exploration of the English history in and of itself. And so maybe it's not necessary to further develop the American implications, but there are a couple of possibilities that I was thinking about and just wanted to suggest. So one is that I think you might think about the role of these changing, I'm calling them technologies, but maybe modes of what happens with statutes and other, well, I would say just changing technologies in relation to American jurisprudence having to do with legislative intent. So there's not only the fact that, the Constitution too is not, the deliberations are not written down at the time or not published at the time, but there's also the changes in reporting subsequently. Then in addition, you might think about not only the changes in kind of legislative documentation, but also in how accessible judicial determinations are, and sort of the rise of Westlaw as a mode of a very different technology for understanding precedent and maybe looking into even the past of earlier interpretations of statutes. Then the final possibility that I was thinking about is also how much should we look to England as kind of advising us about the evolution of American law, or shouldn't we? There's a speech that Justice Ginsburg had given a while ago about looking to English jurisprudence for developments in equity and thinking about changes in equity, and the idea that actually we shouldn't be stuck with a kind of equity that we got from England in the 18th century, but instead evolve along with British jurisprudence. And so I would be curious if that could be an implication of this paper as well. But anyway, I just want to thank you so much for this wonderful read, and I look forward to seeing more. Thanks.
Thank you very much, Bernie. And now we turn to Ilan Moorman.
Thank you. Thanks so much for having me here, and for Professor Amar for providing the commentary on my paper. Which, my glasses are still fogging up. There we go.
Don't thank me yet.
Well, I'm pretty sure I know what's coming. Okay, so the paper takes on the conventional wisdom about the so-called trichotomy of rights in the Reconstruction era, the distinction among civil, political, and social rights. This trichotomy was critical to the court's reasoning in Plessy against Ferguson, and it is widely accepted among modern scholars that this trichotomy accurately reflects the meaning of the 14th Amendment and the rights to which it does and does not extend. Since we're among friends, even Michael McConnell, in his famous Virginia Law Review article, argues that this trichotomy is the key to understanding Brown v. Board of Education and the meaning of the 14th Amendment. What my paper tries to show is that at least if Section 1 is written in legal language and refers at a minimum to the same set of rights to which the Privileges and Immunities Clause of Article 4 refers, then the trichotomy does not make sense. It does not accurately reflect the distinctions among types of rights made by antebellum courts and scholars. Instead of adopting a trichotomy of rights, they really adhered to two different dichotomies, which maybe together makes a new trichotomy, but there's a dichotomy between civil and political rights, which is sort of actually quite conventionally, I think, accepted, and then a dichotomy between private rights and public privileges. Once this is recognized, it actually turns out, I claim, that most of the discourse during Reconstruction is consistent with these two different dichotomies and not with this purported trichotomy. Just why does this even matter? What are the stakes here? Well, because I think it helps us to answer two prominent questions, namely the correctness of Brown v. Board of Education and Loving v. Virginia. If, as I claim, the Privileges or Immunities Clause of the 14th Amendment covers civil rights, then it covers marriage, because marriage is not a political right, certainly not a public privilege. So the point is, marriage is at least covered by the amendment. The question then becomes whether laws prohibiting interracial marriage are part of a system of caste legislation designed to maintain white supremacy. I think the answer to that, by the way, is quite obvious. All one has to do is look at what Chief Justice Taney himself said in Dred Scott. The fact that the laws prohibited such interracial marriage was to him the key indicator of the supposed degraded and inferior status of black persons. Easy case, I think. Brown v. Board, well, public education, it's not a political right. So the question whether the Privileges or Immunities Clause applies to public education, I submit, is to ask whether it covers public privileges. If the clause does not extend to public privileges, then Brown was wrong. If it does, then the clause at least applies, and it again becomes a question of whether separate schools create an abridgment of the privileges and immunities of black citizens, which I also happen to think is an easy case once we get to the merits. So those are the stakes. In my short time, I will assume for sake of argument what I've argued before, which is that at a minimum, the Privileges or Immunities Clause of the 14th Amendment covers the same rights as Article 4 of the original Constitution, the Privileges and Immunities Clause, also known as the Comity Clause. I'll then briefly go over three propositions. First, about social rights in Article 4. Second, about public privileges in Article 4. And third, why I think the Privileges or Immunities Clause might treat public privileges differently than does the Comity Clause. And if it doesn't, then I'm wrong about all of this, but so it goes. Okay, so first, social rights. The Comity Clause, the Privileges and Immunities Clause, provides that the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. It requires a state, say State A, to give citizens of other states the same privileges and immunities that State A gives to its own citizens when those other state citizens are traveling in State A. So the question in antebellum law was therefore, what is the scope of these privileges and immunities that must be given to citizens of other states on a non-discriminatory basis? Well, there is nothing in the antebellum Comity Clause jurisprudence that I could find even remotely identifying a category of social rights. It was widely accepted that the clause covered civil rights, which are largely just natural rights as modified by the laws of civil society, property, contract, and so on, which all free governments must secure. And the clause does not cover political rights, like voting and holding office. I canvassed dictionaries, treatises, cases, the congressional records from this period. I cannot find any indication that social rights, whatever those are somehow excluded from the reach of the Comity Clause. So social rights, I show in the paper, was just another term for civil rights, or for all rights that are stipulated for in the social contract. Under any definition of social rights that I uncover, civil rights in the sense of the Comity Clause's distinction between civil and political rights would be covered. There's no such thing as an excluded category of social rights. Okay. What about public privileges? Here there is no case directly on point, but we have three sets of sources, I guess, that suggest public privileges are not covered by Article 4. They're not guaranteed by the Comity Clause. The first is Corfield v. Coriel, confirmed by the Supreme Court in a case called McCready in 1876. The common resources of a state, like its fisheries and public lands, are not privileges common to the citizens in the several states. They are privileges unique to the citizens of a particular state. That is, they're privileges of special citizenship rather than general citizenship, as the court said in 1876, which is why New Jersey did not have to share its oyster beds with the citizens of Pennsylvania. Right? Part of the rationale here is also resource exhaustion, so the state is allowed to ensure the preservation of its resources, which means limiting access to them, which means reserving access to your own citizens. You don't have to share this public right with citizens of other states. The second set of sources relates to antebellum systems of poor relief. As I try to show in the paper, it was widely accepted that a state could remove a pauper who was liable to becoming a public charge to the state of that pauper's legal settlement. The poor relief laws were limited to those local citizens, to the benefit of those local citizens who did contribute or in theory could contribute taxes for their support. The third set of sources relates to corporate privileges, which were understood to be public privileges. Numerous state laws reserved the right of incorporation to a state's own citizens, and a state could also refuse to recognize foreign corporations. So these cases sounded in similar reasoning. Whether to grant or recognize such a privilege is a matter of mere municipal regulation, not a matter common to the citizens in the several states. So again, public privileges, poor laws, public resources, corporate privileges, not covered by Article 4. Not covered by Article 4. By the way, for completeness, I should say, if we're talking about corporate privileges, it's worth mentioning that there are numerous state constitutional provisions guaranteeing equal privileges and immunities to citizens. In several states, these were specifically enacted to combat the grant of exclusive corporate privileges. I think this suggests that corporate privileges, although not privileges of general citizenship common to the citizens in the several states, were understood to be privileges of state citizenship, at least privileges of citizenship under a particular state's law. Okay. So the question now becomes whether the Privileges or Immunities Clause covers public privileges, even though Article 4 does not. because the Privileges or Immunities Clause must cover public privileges if Brown v. Board was correctly decided. Now, I suggest the answer is yes for a number of reasons, although if I may mix my metaphors, I don't think there's any smoking gun, silver bullet evidence for this, okay? First is a textual difference. The Comity Clause guarantees equality in the privileges and immunities common to the citizens in the several states. The Privileges or Immunities Clause guarantees all the privileges and immunities of a United States citizen within a state, not just the privileges of citizens of the United States in the several states, but all privileges of United States citizens within a state. I think that would include their privileges not just of general citizenship, but also special citizenship. Also their public privileges under state law. Second, perhaps is an obvious reason that comity concerns are irrelevant to the Privileges or Immunities Clause. All citizens of a particular state pay for the support of public privileges and therefore should get to enjoy them equally. Third, if the Privileges or Immunities Clause at a minimum does for intrastate discrimination what the Comity Clause does for interstate discrimination, then I think it's the Privileges or Immunities Clause is effectively a federal version of the various state equal privileges or immunities clauses, which, as I noted, covered corporate privileges. Most of them were written to cover corporate privileges, which were public rights. Fourth and finally, perhaps for those other reasons, all the Republicans, with one exception, who were there in the 39th Congress, who debated in a subsequent Congress the Civil Rights Act of 1875, what would become the Civil Rights Act of 1875, I should say, all but one believed that public privileges like public education were covered. So at a minimum, the argument went, if the state creates public privileges through a system of taxation, then the Republicans believed it had to guarantee such privileges equally. So perhaps public education, public privileges are not common to the citizens in the several states, but perhaps it is a civil right of a citizen of the United States in a particular state. Okay, if I'm right about all this, and maybe I'm not, but if I am, then I think Loving is an easy case. Again, marriage, it's not a public privilege, so that's easy, not a political right, it's a civil right. But Brown then I think is also at least a correct case because public education, although a public privilege, is covered by the Privileges or Immunities Clause. The question then boils down to whether separate schools are or are not equal. That is a question on the merits, and the answer to that question has nothing to do with social rights, whatever those are. I'll stop there and await Professor Amar's invective. Thank you.
Yes, Akil.
Thank you very much for the opportunity to be here. It's always an honor to be with my friends in the Federalist Society. So this is awkward for me because I don't love the paper. And I don't love the previous book, Second Founding. And just so you know, I didn't sign up, I didn't volunteer quite for this firing squad duty. I was invited by the Federalist Society to participate in an event about young scholars, and I said, great. And they said, and here's your assignment. And I said, oh, great. So let me start with the book, The Second Founding. It's an ambitious book, but we're talking about important questions, the central meaning of the 14th Amendment. And there's some good stuff and there's some new stuff, but what's good isn't new and what's new isn't good. So the book gets the biggest and easiest question basically wrong. It tends to suggest that the only meaning, now I think there's been some modification, the only core meaning of the 14th Amendment, Section 1 is kind of an equality meaning, taking, borrowing from the interstate privileges, immunities clause of Article 4 and applying it intrastate. And so in other words, the book tends to basically say that the Bill of Rights doesn't fully apply against the states. Maybe you have a right to have guns equally with other people, but a state could take away a right from everyone, or free exercise, or Fourth Amendment right to be secure against unreasonable searches, seizures, and what have you. And today, to say that actually is somewhere between troubling and incompetent. The major scholarship by left, right, and center, all the major articles and books the last 30 or 40 years have really come to a consensus that once wasn't the case. There were people like Raoul Berger and Charles Fairman who said stuff, but now we have landmark books by Michael Kent Curtis. I wrote one called The Bill of Rights, Creation and Reconstruction. Kurt Lash, Jack Balkin devotes major portions of his book. Gerard Magliocca, new book by Randy Barnett and Evan Burdick. Landmark articles by the leading folks talking about this as well. John Hart-Ely, Doug Laycock, Richard Ains, Kevin Newsom. Now maybe we're all wrong, but then you have to actually present our evidence and say why it doesn't make sense. John Bingham of Ohio authored the Section 1 of the 14th Amendment. This is his speech, which was published as a pamphlet. Honorable John A. Bingham of Ohio, this is my book, The Bill of Rights, Creation and Reconstruction, in support of the proposed amendment to enforce the Bill of Rights. You know, a phrase he used 12 times on one occasion, 6 times on another. So, okay, so now there's a dialing back in this and saying, well, maybe actually some people have suggested that it is about the Bill of Rights, but it's about more than that. Absolutely. But here's what the article says. Here's how we academics work. In D.C., if you write a tell-all book about the insider account in D.C., Buckley once wrote such a book, and he gave it to a friend. And he inscribed in a certain part, because he inscribed it in the index page where that friend was mentioned, and he said, "I knew you would look at this page first." Okay, that's how it works in DC. So of course I first look and see what might be said or not said about my own work, and what's said is ridiculous. It's the exact opposite of my position. And what's said is that I claim that only the 14th Amendment only applies to the Bill of Rights. That's not remotely it might be Kurt Lash's position, and I love Kurt, he's my student, but it's not mine at all. It's about full and equal rights of many sorts, including things way beyond the Bill of Rights. And some people are nodding their heads because this book has sold 50,000 copies and is cited multiple times by lots of scholars in the Supreme Court. And you can't get big things wrong like that if you really want to make a contribution, alas. Now, he then says, well, Amar says it's the Bill of Rights is paradigmatically at the heart of privileges and immunities. It is, but that doesn't mean that it's the only thing. And then he goes on to say, the problem with that is that it means other things as well. Well, of course, I wish I'd said it. Oh, wait, I did. Okay, so that's not so good. Now let's talk about the other ideas in this piece. So on Bill of Rights, and there are some people who disagree. They haven't actually done anything in the last 30 years to challenge the likes of Curtis, Lash, Balkin, Magliocca, Barnett, Burdick, and the rest. One of them is even maybe in this building, but and I invite him to write it up if he dares. But here's where I agree with Elon. There isn't a trichotomy between social, political, and civil. There's a dichotomy, but oh my God, I've been saying that for 20 years, 30 years, in piece after piece after piece. It's civil versus political. Social isn't where it's at. Now, here's what social is about, and I think we don't really have a good account of it, and I'll tell you what I've said in several books and many articles for 25 years. One is the state action doctrine, okay? So in general, the amendment doesn't regulate private people, especially in their private dinner parties, social stuff. Second is, even if Congress is trying to enforce the 14th Amendment, its equal citizenship idea, that first sentence, which doesn't say no state shall, there's a limit on how far that equal citizenship idea can go. It can apply to hotels, theaters, places of public accommodation, but not to my private dinner party. Privacy at certain points constrain congressional legislation and state legislation too. We could think of that as a social domain. In fact, what a lot of people what they really mean by social rights, because he's right, it's a contract marriage, or and the government's preventing two people from getting together, so it's not forcing anyone to do anything. So what makes that any different than the black codes? So a white person can marry a white person, but a black person can't. Why is that any different than a black code? And the answer is because it's symmetric. Oh, the white person can't marry the black, but the black person can't marry the white. And now that doesn't mean it's constitutional automatically. It means that it's not facially unconstitutional, because it's not facially discriminatory, the way the black codes were. You'd have to actually look at the law and purpose, meaning, effect to see, is it really equal? And I'm with Elon. It's easy. Forget that it's in, here I end, that it's in a school or in marriage or in a box or with a fox or on a train or in the rain. It's just not equal. You know, don't look at the silly domain. A law whose preamble says a law to degrade black people, a law to establish the supremacy of whites and the inferiority of blacks in the civil domain is just unconstitutional, full stop, even if the schools are equal in facilities. And you know, yeah, of course Loving is right and easy, and Brown is right and easy, and Charles Black taught us, who's also not cited here, taught us that 60, 70 years ago in a landmark article on the lawfulness of the segregation decisions. So he's right about it's not a trichotomy, and he's right that Brown is easy and Loving is easy, but it's a little bit like Christopher Columbus, like discovering America, you know, when there were kind of people here, you know, first. So to repeat, there is some good stuff here, but it's not new. And there is some new stuff here, actually, but it's not good. It's not taking seriously all the evidence for the Bill of Rights as the central meaning of the 14th Amendment, and then equality along with that. It's the full and equal civil rights at the heart of the 14th Amendment. Thank you.
So I suggest that as people are gathering their thoughts for their questions, that we give each of the principal speakers a moment, because Bernie asked Jonathan, you know, 4 extremely meaty questions. I don't want them to fall off the table, and Akil has challenged Alon, and you know, on a few side points. So
I've got my book. I've got his books.
Do you want to go first, Alon?
No, you first.
Okay. Well, great. Well, thanks so much to Professor Myler for her questions. I, for purposes of time, probably can't sufficiently address all of them. I think I'll maybe just make 2 points in response to some of her suggestions. The first had to do with the institutional and technological contexts in which a lot of these debates about statutory interpretation took place, and the ways in which shifting evidentiary sources opens up new possibilities for how we think about statutory meaning. And I think that's absolutely right. And I think one of the central things I was trying to get across in the paper, I'm working on a second project now to do with the origins of the doctrine of stare decisis, and there's a very similar story to tell there. It's only once judicial opinions begin to be written down that it's possible to distinguish between the central holding of the case and to claim prospectively that holding then binds future judges. So it's a very similar story there as well, and I think that's absolutely right. Just in terms of the question about constitutional interpretation, I mean, one of the interesting things about the English approach is that it's the exact same methods of interpretation that are applied to the Bill of Rights of 1689 that's applied to quotidian statutes that were passed last year. There's no structural distinction between quasi-constitutional statutes in the English tradition and any other kind of statute. And I do think that raises, to my mind, a question about the historical and conceptual reasons why we tend to think of constitutional interpretation as a distinct kind of enterprise from statutory interpretation. After all, the words of the Constitution, just like the words of a statute, are public law that's binding on citizens. Query whether the level of generality that certain provisions are written at should color the analysis. But it's unclear to me, for instance, why we should take a different approach to, say, the Second Amendment because it's enshrined in the Bill of Rights than we would have taken if those same words were passed by statute in 1791. yeah, I don't have a clear answer on that, but it is a question that's come up to my mind in working on this paper. The last thing I'll say, just on the question about the theories of law and legal legitimacy that undergird various approaches to statutory interpretation. I mean, I think that's really the interesting question that this project raises. The question of how a judge interprets a statute, I think, invariably rests, either consciously or not, on that judge's conception of where political legitimacy resides. And a lot of these debates in the English tradition, much like our debates, about interpretation are really epiphenomenal debates about more fundamental questions to do with the separation of powers, democratic legitimacy, legislative sovereignty, and so forth. I certainly don't propose to resolve those debates in the next 10 minutes, so I think I'll just stop there.
Yeah. Okay, well, so there are sort of two sets of comments. One was on this paper specifically, and one is on sort of the book and this broader incorporation debate. I'll start with this paper, which is this, Brown is right and easy, as Charles Black said, who is, by the way, cited in footnote 343 of my paper. But the point here, at least the draft I have now, but I think it's been in there for a while, no one has answered. So Charles Black is correct, right, that separate schools are unequal. But no one has answered the question whether public privileges are even covered. Private education, sure, you can't make one set of laws for private education and a different set of laws of private education. The question is, are public privileges covered? If they aren't covered under Article 4, and no one has had a definitive piece on that, no one has gone through all the sources about comedy and public privileges until this paper, okay? So, and if it's not covered by Article 4, and yet if the privileges or immunities of United States citizens are only those, or at least those covered by Article 4, or which is what Bingham actually said in 6 weeks before his incorporation speech in 1871, and it's what other people said. Just Republican Senator John Trumbull said public education is not covered by the Privileges or Immunities Clause because public education is a privilege. It is not a right. No one has answered this question, whether if the Privileges or Immunities Clause is what gets us to Brown under the original meaning of the clause, whether public privileges are or not covered. No one has answered that. And so that is quintessentially what this paper is about and what this paper seeks to do. As for, can I say one thing about the book? So what I do in this book is I basically take the John Harrison view. I think John Harrison is right about this, that the Privileges or Immunities Clause, at a minimum what it does is it requires equality with respect to civil rights under state law. It's an anti-discrimination provision with respect to civil rights under state law. Can it also then maybe incorporate the Bill of Rights against the states? Maybe, but it's weird. It would be awkward. Because then the word abridge would have do two separate work with respect to two separate kinds of privileges and immunities. Professor Amar in his book sort of recognizes this. When he talks about Professor Harrison's work, he says, well, of course, the privileges or immunities of United States citizens is more than just the Bill of Rights. It's also the common law rights like in Corfield. But does that get us Lochner? And that would be scary, right, if it gets us Lochner. And then Professor Amar says, well, it doesn't have to get us Lochner because, as Professor Harrison says, maybe it only requires equality with respect to those privileges and immunities. But why? Why would that be? It seems to me that that's gerrymandering Professor Harrison's view of civil rights under state law into this understanding of privileges or immunities to get us incorporation without also getting us Lochner. And I think you have, and I just don't know that anyone has shown that that's justified. And my book doesn't go through all of that, but there's obviously a lot more to say about incorporation. But my book does assume the John Harrison position or tries to adopt the John Harrison position. I've got lots more to say on incorporation and Bingham's speech, but clearly a much longer and more robust paper on that has to be written in the future. And it is in progress.
So are there questions? There's a question from someone out in Zoom land. In fact, our old friend Lorianne Updike Toller has written, and this is directed to Jonathan. I'm going to read it to you word for word. Based on a paper I presented at this event last year, there is some statistically significant evidence that history has some constraining effect in constitutional interpretation. Do you think it would be possible to similarly test your normative claims about the use of history in statutory construction in a quantitative way?
It's an interesting question. I don't know how one would go about doing that in the English tradition. So one of the key cases I discuss in the paper is this English case from 1992 called Pepper v. Hart, which effectively has a kind of, introduces a kind of carve-out space in English statutory interpretation in cases where the language of the statute itself is ambiguous. It can't be construed, or it can't be liquidated by reference to the statute's overall purpose. And there's also a clear statement in the legislative record as to the intention of the parliament that enacted it. In that very small set of circumstances, evidence of legislative intention is admissible, but otherwise it's categorically prescribed. So one could run, I suppose, an analysis on Westlaw of all of the English cases citing Pepper and making this kind of move to introduce evidence of legislative history, and then try to do some sort of statistical correlation between that kind of evidence and the sort of outcomes that that the statute produce, or that the cases produce. I don't know. It's difficult to think about because these invocations of purpose don't have any kind of political or ideological valence very often. So it's not interesting. One of the features of the English tradition that I think is interesting is the folks who are most concerned about the use of legislative history in the English tradition tend to be sort of left libertarians who are extremely concerned about the rise of a sort of unconstrained executive. So Lord Stein, one of the former law lords, has made a number of remarks to this effect. So all that to say, there's not a clear kind of political valence in the way that we might think about it in the context of debates over the role of precedent in the English court. So I don't know exactly how one would go about doing that, but it's an interesting suggestion.
There's a question back here.
Another question for Jonathan. When we went through the canons of interpretation, we learned that there was this canon about reading statutes to not go against the common law. And I wanted to ask how it related to your research when you found that, whether you found that there was just so much common law with private law being dominated by contract and tort, etc., that played into the English rule of interpretation, kind of with what was called the early textualism. Yeah. Or the particular mischief, because it was always against the backdrop of like a complete common law private system.
Yeah, that's a great question. Thanks for that. So the system of interpretation that emerges in the early 20th century, to sort of put it in a nutshell, directs judges to give effect to the clear meaning of a statute's terms, and if it's ambiguous, to consult the historical context in which the statute was enacted. And if those things can't resolve the meaning of the statute, then it's simply unenforceable, like an inscrutable line in a will or a contract. But what's interesting is that initial clarity-ambiguity distinction is heavily colored by these kinds of substantive canons, right? So there's a heightened burden for showing that a statute is clear or ambiguous in certain contexts, depending on whether it enlarges or restricts the common law, depending on whether it's a penal statute or a tax statute, and so forth. And so that's how these canons get sort of incorporated into this basic framework that's operative for much of the 20th century in the English tradition. So that's certainly, these kinds of canons certainly play a role in the analysis, yeah.
Josh Blackman?
A question for Elon, and I'm somewhat...
Wait, the microphone's coming so that...
Thanks. A question for Elon, and I'm sympathetic. You take an unorthodox position, right? And
an orthodox?
Unorthodox. An unorthodox position.
No one's ever accused me of orthodox.
No, you're not. And this is just sort of a comment from many of the young scholars in the room. How do you go about sort of preparing yourself to take on one of these sort of really sacrosanct positions, knowing that you'll get the sort of feedback Professor Amar gave? You walk into this. I mean, just how do you do it? I mean, what's your approach? And perhaps I'm guilty of myself, but how do you go about doing it?
Well, the first is, although I do tremble when I talk to Professor Amar often, he's very gracious with his time. We've had long phone conversations about this, and if nothing else, he's convinced me that I need to show more work And so, I'm going to show more work, and as I, write the longer paper, right, I'm open to changing my mind about things, right? So I guess the answer is, even if you're taking on orthodoxy, they're happy to talk to you, even if they chew your ear out or head off, rather. I guess I'm mixing metaphors again. And you just, I don't know it. It's true that I'm not tenured yet, but certainly once I am tenured, my answer to that question will be, well, I get paid just the same, but I'm not tenured yet. Thank you.
Well, I'd like to follow up on that and ask Alon, is it not actually a virtue to take out a position that is not simply the conventional wisdom? Now, it would be helpful if you're right, but...
Yes, it would be. Well, I would say if I'm right, it would be virtuous.
Well,
I feel like that's my answer.
See, what I would say is, as you set out and you're trying to figure out what to invest your time in, it's actually very important to look for things where people aren't all right, where what is being said does seem to be wrong. And I just don't shy away from that. And in this, I'd like to just say that Akil has been helpful to Alon, not hurtful. It's like maybe they sound like they're in a tussle, but this is the way things work, and it's the way things are supposed to work.
I will say that, it does, and I appreciate that very much. It does help being right, or at least you have to think that you're right? Because if you're wrong and just digging up these old debates again, you're just causing a lot of people a lot of work for no reason, right? So you at least have to believe that you're right. Otherwise, you're just making everyone go around in circles and wasting everyone's time, which maybe is what I'll end up doing, having done, in 20 years when I look back at all of this. But as of now, I'm not sure that I'm wrong. So that's why I'm at least going to keep going.
Well, let me try to say, it's not that he's wrong. It's that he hasn't shown remotely his work and he hasn't presented you, the reader. If I say something is in the Constitution, I've got to show you the evidence for that. Many of us have shown lots and lots and lots of evidence. Now, the obligation then in the scholarly process will be for the people who disagree to say, here's the evidence that's been presented, here's why it actually doesn't add up. But when the work doesn't begin to do any of that, it's worse than zero, because someone who doesn't know the argument on the other side isn't seeing it and that's not good. That's fake news. So that's one point. Now here's a second point. So I'm glad he's citing Charles Black. It wasn't in the version that I was given, but I'm glad he is. Some scholars argue that the Privileges or Immunities Clause of the 14th Amendment was intended only to incorporate the Bill of Rights against the states, citing me. Now, I promise you, the one thing that I do know is my own mind and what I've said and what I haven't said. And that's so preposterously the opposite of my position that it does cause me to actually doubt. And because what he says about stuff that I've spent my life studying and know like the back of my hand is so, his account is so opposite to what I think I know and I've put on the page. And when what he says about me I know is not true, that does cause me to worry about all the other claims that he's made when I haven't investigated this or that or the other thing. So you have a reputation to maintain and a trademark, and if you lose that by taking interesting positions that get you a lot of attention, but like Emily Latella, then you have to say, oh, never mind, about violins on television. What's wrong with that when it's about violence on television or something? That's a reference that only the oldsters in the room will get. There's a cost to that. So the way actually the process advances is when you actually take seriously the work that others have done, and then actually join. I want to say one final thing, which is I omitted to mention, because he wrote a very nice blurb for Elon's book, and then and he's one of my closest friends and co-teachers, Steve Calabresi. So I said, Steve, you completely agree with me on incorporation. You didn't initially, you did the work and then you double checked, and our friend John Harrison has a slightly different view, but you went and he's written many pieces on that. And I said, so, how can you actually like this book which doesn't even take seriously all of that? And the answer is, Steve is a more generous person than I am, perhaps. But when you add up, because you can't in 5 minutes do all, have read all this stuff. I'm telling you, so unfortunately, all the people on one side, I know John Harrison has a slightly different view. He's never actually written it up, and I don't think he can actually, given that he can actually persuasively rebut all the evidence for incorporation, which, by the way, is 9-0 in the United States Supreme Court. So this is a pretty big thing to say, actually, the Bill of Rights doesn't apply against the states in 2022. It might have been different in 1943 when Black and Frankfurter are having their debate. So it's a pretty big freaking thing to say in 2022 the Bill of Rights does not apply against the states. Oh my God. And as I said, I know John Harrison has some reservations about, but I don't think he's ever come within 100 miles of actually rebutting the evidence from Michael Kent Curtis and Dick Ains and Kurt Lash and Gerard Magliocca and Jack Balkin and Steve Calabrese. I could go on and on and on. This is pretty well established, I think, by now among the folks who have actually carefully done the work. And if you disagree, you owe it to the community to actually, yes, you're going to have to write a paper. Good luck.
Can I just say a quick thing?
Yeah, I think we should give Alon the last word.
I know, we're over. So just a quick, what my book does and doesn't do. So my book is a short book, admittedly. What it shows is that the Privileges or Immunities Clause has to be at a minimum, an anti-discrimination provision with respect to civil rights under state law. The Equal Protection Clause doesn't do the work, and I show. Then I have a chapter where I'm like, okay, now might it also incorporate the Bill of Rights? What do other people say? And I canvass sort of different positions. And I express my skepticism and my doubt about the incorporation position. And then I say, but it's sort of within the range of plausible meanings. Maybe you can liquidate it, although it would have been liquidated under the wrong clause, which makes it sort of awkward. But I don't even purport to attempt to definitively resolve that question in this book. What I do try to show is it's an anti-discrimination provision with respect to civil rights under state law. And if I'm right about that, I actually think the burden is now on the pro-incorporation people to explain how it could both be an anti-discrimination provision with respect to only one set of those privileges and immunities and an absolute guarantee with respect to certain others. That's what I do. That's what I purport to do in this book, and I promise I'm working on a longer paper. Maybe I will reverse my view on the incorporation, my initial incorporation skepticism. But that's all I purport to do in the book. On the footnote, I'll concede, I actually read the paper on my way here on the airplane, and I saw that footnote, and I was like, oh shit, this is probably not an accurate explanation or description of Professor Amar's position, because, I think under his view, you can also get Griswold v. Connecticut if enough states do it. And so, yeah, this is a first draft. No one has commented on this. It's the same paper 2 weeks ago Michael and some others commented on, but and it's a first draft, and I'll change that footnote. But the position remains the same, that I don't see how you can both have incorporation and this anti-discrimination view, and those are the two that I'm trying to disentangle here. But it's a first draft, and I will certainly amend that footnote for sure.
So this has been a foretaste of all the fun
being a professor
you have in front of you. So thanks to our speakers.
Thanks, everybody.